Welcome to Rethink, Rebuild, Reform, a podcast by Mothers for Mental Health Care Reform. Mothers for Mental Health Care Reform advocates for improvements for people living with serious mental health disorders, such as schizophrenia, bipolar, and psychosis. According to the Canadian Mental Health Association, about 1% of Canadians will experience bipolar, and another 1% will experience schizophrenia. Mental illnesses are caused by a complex interplay of many factors. These illnesses are treatable, and people living with these illnesses can recover well and carry on regular lives. For this reason, Mothers for Mental Health Care Reform campaigns for people with serious mental health disorders because they deserve access to better practices in assessment, treatment, and rehabilitation, with families included in their care at all stages of the process. Mothers for Mental Health Care Reform want to provide you, our listeners, with information. There are many pieces of this journey to unpack, but we cannot do it all in one episode. So today, our topic is substitute decision maker, or SDM for short. I have a couple of mothers today who have been on their own journey with their loved ones. These mothers will help me dissect the term substitute decision maker by providing our listeners their experience and asking the questions you may have when you hear the term SDM. To help us understand what this is, we have Lisa Feldstein of Lisa Feldstein Law Office as our guest. Lisa's career started in a downtown firm advising healthcare organizations. During this time, she noticed that patients' families did not know where to turn or what their rights were, leaving families feeling powerless and confused. Because of her experience, she started helping struggling families navigate the system. Welcome, mothers, and welcome, Lisa. Lisa, thank you very much for being here today with us. One of our mother's daughter was declared incapable during the first hospitalization, and immediately the doctor asked the mother to be an SDM. The doctor explained what it was and what it meant, and at each hospitalization, she, the mother, has been asked if she would continue as an SDM. I have had a different journey in that after 5 hospitalizations, I never heard of this term until approximately 3 years ago. So I am sure that there are many caregivers out there that have never heard the term substitute decision maker or SDM before this podcast. Can you help us understand this term and explain to us what SDM is and what are the duties of an SDM?
Yeah, so there's lots to cover. The term SDM, or substitute decision maker, is one that we use in Ontario. So if somebody's listening from a different jurisdiction, they might have slightly different laws or even different terminology, although it will be similar, but what I say might not apply exactly the same outside of Ontario. So a substitute decision maker, the way I often explain it is with a sports metaphor, which I'm not a sports person, but the metaphor works. I often explain a substitute decision maker as though they are on the bench. They may or may not be called in to play, and it will depend on how the game is going. So using that metaphor, a patient may or may not need a substitute decision maker, and that's going to change and evolve over time. It may be that the patient or player is not doing so well, and they are unable to make decisions for themselves, in which case their substitute decision may be called into play. So I use that metaphor because it kind of highlights this idea that it's very fluctuating in nature. It's not a status that's permanent. It can change over time based on how a patient is doing. And in Ontario, this idea of a substitute decision maker, it's a legal position and it can happen automatically. There's no piece of paper that necessarily comes along with it. The source of this is the Healthcare Consent Act. So we all have a substitute decision maker, every one of us, because anyone can become incapable. And so the law gives guidance on who that person is, and we can talk probably about who that is and what the criteria are, and you asked about the duties, but the law tells us exactly who a substitute decision maker is. So if a patient can make their own decisions, the law guides us to a list, and we can figure out from there exactly who will be called into play to make treatment decisions for the patient.
That's very interesting. Does anybody have a question for Lisa?
What is the hierarchy of, because I know that in my case, at some point, I was a substitute decision maker. However, the doctor in the hospital decided that my son's voices were from me, and found that I should not be the substitute decision maker. So they made my son substitute decision maker. However, at that time, he was totally incapable, and it just wasn't a good scenario with the doctor not understanding that my son was quite ill, but seemed very capable at the same time.
Yeah, so this hierarchy, it comes from this Healthcare Consent Act, and we call it a hierarchy because although it looks like a list, the way the law works is we go from top to bottom, but at any point, if a patient is considered capable, the list is really not applicable in that moment. What makes things particularly confusing is a patient might be capable of some treatment decisions, but incapable of others. So when it comes to their mental illness, they might lack insight and be incapable of decisions about antipsychotics, but capable of whether to get the next COVID-19 booster. So it's treatment specific, but this list, the top of the list is guardian of the person. That is the top. So if there's a guardian, that is, we know that would be who the decision maker is. Most people don't have a guardian. If they do, it will have been a court process. So some people wonder, how will I know if there's a guardian? I didn't seek it. Could there be some other guardianship? Families should know because they are supposed to be served under the Substitute Decisions Act. And in Ontario, if somebody really wants to check, it's actually possible just to pick up the phone and make a phone call and find out. The Office of the Public Guardian and Trustee keeps a registry of guardians. So families should absolutely know, but if they're for some reason not sure, there's a place to call, give the name, and despite all of our other privacy laws, they can be told if there's a guardian of the person. And then second on the list is if there's a power of attorney for personal care, whoever is appointed under that document, that's where people can choose for themselves their substitute decision maker. This is where legal issues can arise though, because sometimes they're called into question, is this document a valid document? Was the person capable at the time that they signed it? So power of attorney can turn it into some complicated scenarios. Third on the list is quite unusual, but it comes up from time to time, and that's somebody who's been appointed by the Consent and Capacity Board. Like with guardianship, family members would generally be involved in that process. They would generally know, but that's an appointment that comes from a tribunal, and it can be sought by the family member themselves, or it can even be sought by the patient through a process known as a Form C or Form B. And then after that, there's spouse or partner, and the law goes into a little more detail about the definitions of spouse and partner. And it can include somebody who's not married, who've been living together for a year. So there are some circumstances where people may not be considered spouse or partner, or may be considered spouse or partner contrary to what they might assume from common sense. And then we've got, it can be children, it can be parents. When I say children, 16 and older, or parents of the individual. And then we can look at siblings and eventually any other relative. And if there's nobody, then the Office of the Public Guardian and Trustee. And so within that hierarchy, we go from top to bottom. There's other law that fills in gaps, such as what are the criteria these decision makers have to make? What happens if more than one of them do not agree, or they want to effectively outrank each other? So we can go into more detail, but that's sort of the top to bottom hierarchy, which means physicians and other healthcare practitioners don't have discretion to say, I like this substitute decision maker better. They're a healthcare professional, or the patient seems to like them more. That favoritism or selection isn't actually part of the law.
Thank you. Why would I want to be designated as an SDM, and what are the benefits?
So it's not even so much a designation, it's almost just this automatic default status that happens based on a patient being found incapable of a particular treatment decision, and they're the person in line. The benefits, though, practically speaking, tend to be the right to consent. If a person is found incapable, they legally lose the right to make that medical decision, at least for that point in time. And with most of my clients, what I see is it's a family member with a mental illness who lacks insight, doesn't want to take medication because they don't realize they're unwell. And so by virtue of them being found incapable, their substitute decision maker is given the authority to consent or decline to that medication. Most of the time, my clients as family members want to consent to what the psychiatrist is proposing, get their loved one back on or on medication, and hopefully improve the condition. So the real benefit is having that authority to say, yes, I agree with the proposed medication.
Some of our family members are not consented on becoming a SDM and are not have access to their medical information and are not involved in making decisions. What can a family member do if that happens?
Yeah, and this is a real challenge for a lot of family members, is they're very excluded, even though, of course, we know at home they're the caregiver. They're the ones keeping everything together, providing financial support, ensuring their loved one takes medications, stays out of trouble, and yet often due to privacy laws, they are often excluded. Sometimes that's the privacy laws as written, and sometimes it's a perception of privacy or fear of a privacy breach that leads to boundaries that maybe, where the walls could maybe come down a little bit. But ultimately, if a family member wants to be involved, they can be asking. We actually wrote an ebook for 10 things to ask for a psychiatrist to get more information without breaching privacy law. So I'll share some of the tips we put in that ebook, and happy to send that for anybody that wants to reach out I can send that link. So within that resource, we've provided some guidance. So one tip, because I don't think I'll remember all 10 off the top of my head. One is asking for information, but in a general sense. So, okay, you can't share details about what my loved one said, but I know they're on this medication and they have this diagnosis. Can we talk about those things in general terms? What are the signs that the medication's working, or side effects that would mean we should be seeking medical care? So having the conversation, but in general terms, so nothing is being revealed about the individual. That can be one helpful way. Another can be reminding the healthcare provider that consent to privacy can override these privacy concerns. Now, there are, of course, times where patients say, no, don't talk to my family, but sometimes there can be room for breaking that yes-no binary into pieces. So maybe don't share anything with my family, but yes, you can tell them the day I'm going to be discharged home. So trying to tackle it from a more piecemeal perspective to say, well, will you ask my son if X information can be shared? And that's one thing where I've seen a lot is families aren't told the discharge date. They don't know when they're stepping back into that caregiver role. So trying to separate the piece of information that's needed so the healthcare provider can then get patient consent on a discrete basis to at least get something. So that's another way to try and open that door a little bit within the privacy rules, because if a patient consents, then generally there's no problem to share the information.
Earlier, Lisa, you mentioned that there is no form or no document with respect to the SDM. So does that mean that an SDM is recognized in just one hospital, or are they recognized in all the hospitals throughout Ontario, or how does that work?
Yeah, so it's the same law throughout all of Ontario. And the reason there's no document, in some cases there can be, but for example, I am a substitute decision maker for my 2 children. They're minors. They're not at an age that they could be considered mature minors. I don't have a document. I just have a birth certificate, which I've never needed to show. It's just automatic by virtue of going down this hierarchy. Now, what I have found is with older children where their parents are making decisions, that is sometimes they receive pushback from healthcare providers saying, well, show us the document. And truly a document does not necessarily exist if the role is by virtue of being a parent where they land on this hierarchy. I have written letters for clients that essentially say, here is the law. My client falls on this position, it's default. My letter is creating a document so they can hand something in, but that really shouldn't be required. Some people do have a document if the circumstances are different. So if there is a power of attorney for personal care, that is the document. If there's guardianship of the person, there is a court order. And if someone's appointed by the Consent and Capacity Board, there is a document that was produced by the tribunal. But for people who fall lower on the list by virtue of being a parent, a sibling, a child, there is not a piece of paper. And that's actually another resource that we've created. It's a free resource we've created where people can generate a letter. That's focused more so for individuals if their child has disabilities and they know capacity isn't fluctuating. It does get a little more complicated with mental illness because capacity can come and go. So somebody's status as a substitute decision maker can come and go. But absolutely, the role is the same throughout Ontario. Sometimes what being an advocate means is just knowing the law to be able to point to it and say, here is Section 20 of the Healthcare Consent Act. Let's go down this list. I'm the decision maker. And sometimes it's a matter of knowing the law to be able to provide that education in a respectful way, but provide that education to remind healthcare providers that you are the decision maker if the patient's found incapable.
Very good. Thank you.
Uh,
So does,
Leslie?
I just wonder what happens if you go to the justice of the peace and they ask for proof that you are the substitute decision maker.
So the justice of the peace shouldn't necessarily need proof in all cases that someone's the substitute decision maker. Usually if someone's going to the justice of the peace, they are seeking to have an individual brought to the hospital to be assessed by a physician and trying to have them formed under the Mental Health Act. So most of what's being conveyed is examples of the individual's conduct to show that they do meet the criteria under the Mental Health Act, that risk of harm, the likelihood of harm to self, serious bodily harm, serious physical impairment, or harm to others, all of that. So they absolutely might be able to get a Form 2 from a justice of the peace without proving who is the substitute decision maker. It may not be relevant, but if they are going to prove it, then they might just have to show this list and walk through it and provide that context and say, I am the parent, and provide that context of, it's almost more of a legal argument because there isn't a document. I mean, sometimes it's hard to prove the absence of something. To prove there isn't a power of attorney for personal care is a hard thing to prove. There is no registry. Unlike guardianship, there's no power of attorney registry you can call, and you can't really prove a negative. So it would be a matter of sharing that section of the law if needed, and then walking down that list and saying, well, there is no spouse or partner. I'm the parent. But often that's not necessary in order to get a Form 2.
And that's interesting because one of our mothers was refused a Form 2 by the Justice of the Peace because they could not prove that they were the designated SDM. Later, they found out that there was no official document, but it was documented in the patient chart. And now that family member has a letter from Sunnybrook confirming they are the SDM. And even though the letter is a couple years old, when they attach the copy to the Form 2 applications, it seems to help them get their family member.
Yes, this is the challenge with there not being a document, and why sometimes I said we've written letters or individuals can cite the law. Sometimes we send Section 20 of the Healthcare Consent Act to people so they can point to it and say, this is how it works. There just isn't a document that comes with my status. And so by kind of creating one by virtue of an official looking letter sometime, or getting a letter from a healthcare provider, although legally that letter is not required, just having it on a piece of paper sometimes seems to help move things along.
I have a question. What are your rights as the SDM? Because if a psychiatrist, let's say on an ACT team, does not consult with you on your son or daughter's treatment, and you can show the psychiatrist that your son or daughter is not taking their medication, and you are, by that document, you're supposed to share if your loved one is taking medication or not, and they're they're non-compliant. But the psychiatrist, when looking at the at your loved one, deems them capable, even though you show that they're not taking their medication and they're not following the CTO. So what can a family member do if the psychiatrist does not adhere to the CTO as your rights as an SDM?
So the first part of your question, just what are the rights of a substitute decision maker? When it comes to treatment, it's the right to provide informed consent, and the informed is the important part. So it's not just saying yes because a psychiatrist proposes it, but it's the information that a patient would have access to. What are the risks, the benefits, the side effects, alternatives, all of the same information that you would have for yourself as a patient or your loved one would have for themselves if they're consenting. So substitute decision makers are definitely entitled to information, because otherwise the informed part is absent. So that would be the first part of that. But then in this anecdote here, if a patient is ultimately found capable, families can't override the clinical discretion in these circumstances, and capacity can change. So what can happen is a patient starts taking medication. Maybe they've regained capacity, that's possible. And there's also times where healthcare professionals will start out assuming a patient is capable, when to the family member, they are clearly not. But the reason they start out with that presumption is the Healthcare Consent Act and the Substitute Decisions Act has what's called a presumption of capacity. So the starting place when interacting with the patient is assume the person has capacity. So that might be where they begin, unless they start to see those red flags or reasonable grounds that the person lacks capacity, but they will often start there because that's the expectation under the law. So in terms of what can a family member do, it's sharing information to say, I don't think my loved one's capable. Here's why. My loved one doesn't think they have a mental illness. And I often encourage my clients to share if that's in writing, if they have emails or text messages denying a mental illness or other things to support that the person lacks insight, then I will often encourage them to share that. So the healthcare professional might start with that presumption, but with more collateral information might start to see things differently, or over time through their interactions with the patient might start to see things differently.
And in certain cases, it has worked well, and sometimes it hasn't. That's unfortunate, because I think it's up to the psychiatrist or the mental health practitioner on how they review the SDM criteria.
Well, the matter of whether somebody's capable or not is definitely, it's a matter of clinical discretion, and it's also quite fuzzy. It's a very abstract concept, and technically more than one healthcare professional could interview the same patient and potentially reach different conclusions. It's not as black and white as the results of a blood test might be. So there is room for different kinds of interpretation. And then there are definitely, I've seen times where some health professionals, understandably, they want to have a relationship with their patient. They're hoping their patient will come to trust them. And I think that results in finding them capable a little longer than the family member wants, because they're hoping that there'll be buy-in from the patient and agreement to take medication of their own volition.
Lisa, I'm going to circle back to my earlier question about the hospital and whether or not it's recognized in all the hospitals. So other than the hospitals, is an SDM recognized in the mental health community? Is it limited to just inpatient care? How does that work?
No, it's very broad. It is not just mental health. It's not just hospitals. The Healthcare Consent Act applies across Ontario for all treatment. And that is in a family doctor's office or anywhere there's treatment. And we're not just talking about treatment from physicians. Technically, it's much broader treatment. So it is the main consent law that applies across Ontario.
Wow. I didn't realize how complex this whole thing was.
It's broad.
Or is.
The reality is there's practical challenges that come up. So the law is very broad in terms of its application, and it applies to all treatment settings. The practical reality is that life is harder than the law makes it seem, whether that's matters of interpretation or some treatments cannot be forced. I don't know how cognitive behavioral therapy or engaging in any kind of talk therapy can meaningfully be forced, even if a substitute decision maker in theory consents. And there's also limitations if it's provided somewhere that's a voluntary setting. Addiction is one place where my clients have come to me, loved one has an addiction, and it's really difficult to do anything about that legally because most of the facilities are going to be voluntary. And if the individual doesn't want treatment, it doesn't matter that the person might lack capacity and the substitute decision maker is willing to consent. It's just the system's not set up that way to provide certain kinds of treatment in a way that can be forced, or the setting isn't one that has patients on an involuntary basis. So there are a variety of practical challenges despite the broad wording of the law.
Can a patient disagree with their substitute decision makers, or?
So they can actually disagree with being found incapable. So it starts even before that. And yes, patients have a lot of rights in Ontario. So if a patient disagrees with the finding of incapacity, what can happen is they can actually appeal that finding at the Consent to Incapacity Board. They can have a lawyer appointed for them from Legal Aid Ontario, so they're not out of pocket. They can have a rights advisor, and actually will have a rights advisor if they're within a psychiatric facility. A rights advisor will come speak with them, share with them that they have this right. They will help them get a lawyer, file the application to the Consent and Capacity Board. A hearing is supposed to happen within 7 days. And then if they lose that hearing, they can actually appeal to court as well. So there's a bundle of rights and protections there for patients who are found. And it is a big deal to be found incapable. You're losing autonomy over your body and to decide what medications go in your body. So with that infringement comes this bundle of rights: access to a lawyer, access to a tribunal, a rights advisor, right to appeal. And then the substitute decision maker is bound to follow a patient's wish. So even if they lose that challenge and they're stuck with their substitute decision maker, the substitute decision maker has to follow a prior capable wish that the patient made when they were over 16, if it's applicable to the circumstances. So if that patient made a very clear wish, doesn't even have to be in writing, the substitute decision maker has to follow it. And that might be the substitute decision maker actually disagrees and says, I don't think this is for you. I wouldn't decide it for me, but it's your prior capable wish and I'm bound by that. And if there's no wish, then it's a matter of best interest. And even best interest takes into account the patient's values, wishes, beliefs. So there's layer upon layer of patient rights baked into our Mental Health Act and Healthcare Consent Act.
So I'm assuming, based on what you're just saying, is that the patient can change his or her SDM if they so wish.
To a point, yes, absolutely. They have a few options to do that. The caveat for one of them is they have to be capable of doing so. So a patient can make a power of attorney for personal care and appoint someone other than the person that's their default decision maker, but they have to be capable. And the bar for capacity for this particular type of capacity to make a power of attorney for personal care, the bar is quite low. So a person might be very unwell, not on medication, but in theory capable of making a power of attorney. So that could be something a patient could do. They could also bring a Form B to the Consent and Capacity Board. That's not done very often, but it's another way of having a legal proceeding that would happen, with the result potentially being that somebody else becomes the substitute decision maker.
What is a Form B?
So a Form B is an application, and you can find one on the website of the Consent and Capacity Board. It's an application that is filled out and it initiates a hearing at the Consent and Capacity Board that is essentially a question of, should the person that the patient wants to be the substitute decision maker be their substitute decision maker? A similar application, the Form C, is the one where somebody who's not the SDM can seek that status. So if there's multiple children, for example, 3 children, and they're all decision makers together and they're not getting along, and they're equally ranked, one of them can bring a Form C to the Consent Capacity Board and say, I want to be the decision maker alone without my siblings. We're equally ranked. I would like to outrank them and be the proposed representative. So the Consent and Capacity Board is a tribunal, kind of like the Human Rights Tribunal or Landlord-Tenant Board. It's not like a court, but it does have the authority to make a legally binding decision that can then be appealed through the courts. And they will hear evidence from the parties and ultimately can make a decision about who should be the substitute decision maker. But it's very rare that I ever hear about Form Bs happening. I don't think they happen very often.
Are there any times when an SDM is not recognized other than what we mentioned earlier?
Yes, a couple times things, because there's actually eligibility criteria. So the SDM has to be capable themselves. And on a few occasions, not often, but definitely 2, maybe 3 times, I've seen the SDM themselves were found incapable. The real challenge for those SDMs is there's no recourse. There's no ability to appeal. There's not a lot that can be done. If that happens, they're a lot more limited. But if they are themselves incapable, then the healthcare practitioner can look to the next person on the list. They also have to be willing. So it might be the direction where the substitute decision maker says, I would like to bow out. I live far away. My siblings have it. This is too much for me. It's too much conflict in our relationship if I'm also the one making these decisions for all the different reasons. If a substitute decision maker is not willing, then they are not eligible. And then they also have to be available. And available doesn't mean physically close. A lot of people think that means you have to be able to be within a reasonable driving distance, but that is not true. But they have to be able to be contacted in a reasonable amount of time. So as long as they have good phone service wherever they are, a person can continue in the role as substitute decision maker. So, but if they're not available, they consistently can't be reached. The healthcare practitioner might say they're not available, therefore they're not eligible. Let's move down the list to the next SDM.
I have a question. Are the family members supposed to be notified that they can be the SDM?
Yeah, I think there's a lot of miscommunication and probably work to be done in terms of that communication with hospitals. I even found myself, I had a surgery during the pandemic and I was asked about my next of kin, who to call, which is a different discussion than who is my substitute decision maker. And yet I was being put under medication, unconscious, and I wasn't confident they knew who my substitute decision maker was. I thought that should be a discussion we have ahead of time where I give the name and the phone number, and who my emergency contact is might be different potentially than my SDM who's maybe out of town. So I think there's not always a lot of great discussion. I think we could do a lot better. The collective we could do a lot better. What I often encourage my clients to do, though, is bring themselves forward, make it really easy for the healthcare professionals to do their job. So I will often say, tell them you're the substitute decision maker, give them your phone number, be proactive so that if patient is found incapable and they're looking for consent from you, they know how to reach you. So I often suggest people will be proactive in sharing and reaching out and not leave it to the hospital.
One of the family members asked if the patient gets an advisor for their legal rights, just a second, for their legal rights, not the family, not the doctor during the CCB hearing. Iris, do you want to talk to that?
My question is whether it's possible for the family to get this similar legal advice that the patient gets. And it's my understanding that the doctor does not get any help at all to prepare for a CCB hearing.
Yes, and you have stumbled on exactly why I created Family Health Law in 2013, is I observed family caregivers were not getting legal advice and patients had advice. And sometimes physicians will get support, sometimes they won't. It will depend on the hospital, and it can be the frequency of the hearings at the hospital if it makes sense for them to have in-house counsel to deal with these matters for them. But you're right, often physicians will represent themselves at these hearings as well. So the family can choose to get legal advice, but it won't be covered by legal aid. They would have to pay out of pocket if they wanted to actually have a lawyer advise them or represent them.
Are there any other areas that may be of interest when it comes to the substitute decision maker that we haven't touched upon?
We touched upon it, but only on a higher level, so I can go into more information about it, which is the duties of the decision maker. So I mentioned the obligation is to follow a patient's prior capable wish if it's known and they were 16 or older, and it applies to the circumstances. And then there's the matter of best interests, which are a list of factors. A lot of substitute decision makers know they're in that role, but they just sort of intuitively say, well, the doctor proposed this or this feels right, but they don't know there's a list of factors in the law actually saying, here's a bunch of things you have to consider and weigh in deciding what is in a patient's best interest. So some of those are the values, wishes, beliefs. Some are more medical kinds of factors about whether the intervention is likely to make the person better, prevent them from getting worse. But what we haven't talked about is what happens if the substitute decision maker declines the treatment, then what? And so in some cases, the psychiatrist or whoever's proposing the treatment will be okay with that. Not every treatment is proposed with an expectation of consent, and that would be problematic if the only answer in all cases was consenting. It sort of makes informed consent meaningless. So there must be room for refusals. But what can happen is if there's a healthcare provider who's really concerned that the substitute decision maker has got it wrong, that they're not complying with the principles of a substitute decision maker, the healthcare practitioner actually has legal recourse. They can complete a Form G application, bring the family member, bring the SDM to the consent and capacity board where there can be a hearing. So if a family member is refusing and it's clearly to the healthcare provider, clearly not in the patient's best interest or in accordance with the prior capable wish, there's recourse to have a hearing in that respect as well. And I don't know if I've ever seen that come up in the mental health setting. Generally, I will, practically speaking, I'll see that come up in an end of life setting, where a family member isn't consenting to the removal of life support is the most common scenario. But it's the same law that applies for end of life decisions, antipsychotics. It's the same Healthcare Consent Act.
It's interesting. Very interesting. Does anyone have any other questions or concerns?
Well, it seems like there's a lot of gray areas with the Substitute Decision Making Act. It's sometimes because of the family member may appear incapable to the family members, but the psychiatrist feels that they are capable. And I've seen cases where their family members have shown so much information, videos, medications that haven't been taking, financial, distress and all sorts of things. And still, the family member as an SDM has been dismissed.
Mm-hmm. And this is where the education piece comes in, because what they're sharing may or may not be relevant to what they're advocating for. So sharing financial information is exactly one where I see people say, here's all the evidence that they're incapable. And a lot of the focus might be on really poor financial decisions that maybe demonstrate that they're not capable of making property decisions. But if they're advocating for their loved one to be found incapable of a treatment decision, the property information might not be so relevant. The same is true if they believe their loved one should be admitted and placed on a form and they're advocating for that. Sharing the property information, maybe a few sentences, but it can be that they're actually focusing too much attention on information that's legally not relevant to the decision being made. So if a physician is deciding if a patient is capable or not, what they're really focused on is the test for capacity. So Section 4 of the Healthcare Consent Act has this test, and it's just words that get applied, but is the patient able to understand the information relevant to making the treatment decision in question? Are they able to appreciate the reasonably foreseeable consequences of a decision or lack of a decision? So if the advocacy is focused on my loved one's clearly not capable of a treatment decision, and here's why, then the here's why should be followed by support of relating to that test for capacity and going down a different path. Sharing specifics of delusions, sharing financial mismanagement doesn't help the physician who's got a couple of minutes to make a decision about capacity. So knowing and really clearly what's the goal and what are they trying to advocate for, and what's that test that the physician has to follow, and then sharing examples that support whatever it is that they're trying to get to happen.
And what happens if at that point they are not heard? What recourse do they have?
Yeah, sadly, this happens so often. It is unbelievable how hard it is to help a family member get better. It is really hard, and they're not always heard. Advocacy makes a difference, but it doesn't work all the time for everyone. It just, big picture, it makes things slightly better for more people. So sometimes it's a matter of trying again. Sometimes it's a matter of collecting more evidence. So taking pictures, taking screenshots of text messages, writing things down when they happen, going back to a justice of the peace and hoping you get somebody different the next day. So trying again, communicating more. I find so many people have told me stories of they get a Form 2, their loved ones brought to the hospital and then sent home shortly after, but they were never heard by the physician. The physician only spoke with the patient. So sharing more collateral information, getting in front of the physician or showing up in the ER, sending something in writing, but trying to share more collateral information, because often where things will fall apart is the individual who can mask their symptoms quite well, and there's not collateral information to help a physician make a comprehensive assessment of what's really been happening.
You mentioned before that, discharge planning, the SDM should be involved and be notified. However, I'm finding from many family members that their family members are being discharged without them being notified.
Yes, I've seen that often. And generally the reason that's cited is privacy reasons. And often a patient doesn't want their family member to know that they are being discharged. So the healthcare providers are always walking this line of what are they allowed to share. And what's really confusing and frustrating is there's different interpretations of privacy law. It's not applied consistently across privacy officers or hospitals. So there's definitely inconsistency. But yes, family members are not always told. It's a real shame because they are the ones providing the support system. But sometimes for privacy reasons, if an individual has made it very clear that they don't consent to that information being shared, there are times that it can't be shared. So my comment before was about trying to get information in a piecemeal way to say, all right, my son doesn't want you sharing X, Y, Z. Can you get his consent to just share the date of discharge, and trying to advocate for piecemeal information to be shared. But yeah, sometimes substitute decision makers or family won't be told because there's not a need for them to be told within what the legislation is recognizing. So a substitute decision maker has to be given information to make a treatment decision, the risks, benefits, side effects, alternatives. That much is clear in the Healthcare Consent Act. But if it falls outside of a treatment decision, there might be less information flowing. An exception might be around a community treatment order where substitute decision makers are involved. Through that process, they might have access to a bit more information. But yes, this is one of the real practical challenges of being a caregiver and being shut out, even though once the person leaves the facility, it's usually the family that's then keeping the individual from being homeless or stopping to take their medication and all the other problematic and terrible outcomes that we know can happen.
Well, there are many times that we see family members that have been discharged and they are homeless or they have left the country, and the poor family members don't get notified until after, and they're quite ill still.
Yeah. Oh yes, I've seen that multiple cases where an individual left the country and family member hired a private investigator, and they found out their loved ones in jail and in a country abroad with no money, and some really scary circumstances.
Lisa, you've clarified so many points for us, but one thing that I always find quite a puzzle, is it possible that a patient is held involuntarily and at the same time they're capable of making their own healthcare decisions?
It sure is, yes, because there's two different laws, and in Ontario, there are separate laws. So the Mental Health Act sets out the criteria to be admitted as an involuntary patient. The Healthcare Consent Act sets out capacity. So if they're capable under the Healthcare Consent Act, but they meet the criteria under the Mental Health Act, they can be admitted and also capable and refusing treatment. So that is technically possible. And I kind of have this emphasis on technically, because sometimes for ethical reasons, when there's such a shortage of beds, what may end up happening is this sense of, well, then why are we keeping the individual here? And they might be discharged because they're refusing, even though they actually meet the criteria and there is a risk of harm to themselves or others if they're free to go. And the hospital is rolling the dice sometimes on making that judgment call, but they might feel ethically conflicted to keep a patient that they're unable to help. The other situation that can happen is a patient who is found incapable but can't be helped because they are appealing the finding of incapacity to court. The court process takes a long time, or some cases end up getting stuck in limbo, not moving forward at all. So treatment can't be commenced because there's an ongoing lawsuit about their finding of incapacity. They've been found incapable. Substitute decision makers saying, yes, please treat. They're complying with the principles of substitute decision making. They had their lawyer, they had the rights advice, all of that happened, and yet the hospital can't treat the person because there's this appeal sitting in the court system. And we know pretty much all of those cases ultimately are not successful for patients, but in that window of time, they can't be treated. So they are on a form, they meet the criteria under the Mental Health Act, they're incapable, and they can't be treated during that window of time.
And what happens about the criterion that they're likely to deteriorate, they're likely to get worse, and that actually does shrink the brain tissue, as I understand?
Yeah, I mean, those are factors within the Mental Health Act in terms of the criteria that are considered by a physician, is the risk of deterioration if they're not admitted to the hospital.
So
But
it's not
also-
strictly the harm to self and others.
No, and actually, when a person is admitted to the hospital, there's these forms that we've kind of talked about, but there's two different boxes on the forms. There's the box A and there's the box B. And when it comes to the box B, that is a category of criteria. It doesn't apply in all cases, but that's intended for individuals who have gotten better on medication. Clinical improvement is the language. They've gotten better on medication to some extent, and they're apparently incapable. And apparently it's kind of from that, first glance, initial assessment, they seem to be incapable, and their substitute decision maker consents. Maybe that's why when somebody was asked by a justice of the peace about who the SDM is, maybe they're thinking about that part of the criteria. So they're apparently incapable, substitute decision maker consents. We know medication works. The idea of the box B is get this person back on their medication because we know it works for them, because they're deteriorating. So often that's the pattern, is an individual stops taking their medication and everything goes downhill. So for the box B, that deterioration can be a relevant part. And under box B, it's likely they will end up being treated because they came in the door with an assessment that they appear to be incapable of making treatment decisions about that medication that has been shown to work.
This has been an extremely informative session and has provided us with a lot of valuable information. Lisa, thank you so much for your insights and for your knowledge and background about this extremely complex process. As I mentioned earlier, serious mental health disorders are treatable. Let's stop the stigma. Let's get our loved ones access to the best practices in assessment, treatment, and rehabilitation, with families included in their care at all stages of the process. Thank you, everyone.